right, welcome everyone. My name is Dan O'Hanlon. I'm a partner here at Kronick, Moskowitz, Tiedemann and Gerard in Sacramento. Welcome everyone here in the room, and we have quite a few people online as well. We have a terrific program for you today. We're going to learn about Sackett versus EPA, a recent Supreme Court decision involving wetlands jurisdiction under the Federal Clean Water Act, and a decision by the U.S. Supreme Court on May 25th, just a couple months ago. And we're very fortunate today to have the lead attorney for the plaintiffs in that case, Damien Schiff, who's far into the table on my right. Damien is a senior attorney with the Pacific Legal Foundation based here in Sacramento, and where he heads the environmental practice group. Damien has a JD from the University of San Diego Law School, and his undergrad was at Georgetown. Before joining the Pacific Legal Foundation, Damien clerked with the U.S. Court of Federal Claims. It's a very interesting court in D.C., for those of you who are not familiar with it, that handles breach of contract and takings cases against the United States. Very specialized and interesting court. But we're very fortunate. I'm excited to have Damien here today to talk to us about the Sackett versus EPA case. And to ask him questions today, we have two very experienced practitioners. Next to Damien is Brenda Bass. Brenda is a water and agricultural policy advocate with the California Chamber of Commerce. Prior to joining the Chamber, Brenda was in private practice here in Sacramento, specializing in environmental and resources law, especially water quality regulation. And then closest to me is one of my colleagues, Bernadett. She's a colleague here at Kronick Moskowitz who specializes in water, natural resources, and public agency law. And she is also an adjunct professor at the University of Arkansas School of Law, where she teaches ag water law. So the format today, we're going to start with Damien giving a presentation and overview of the Supreme Court's background to the case and the Supreme Court's decision in Sackett versus EPA. And then Brenda and Lauren are going to have a series of questions and really try to have an informal discussion really about the case, the implications of the case. A couple of other administrative details. We're not going to be set up to be taking questions today directly online, but those of you who do have questions for any of the panelists are welcome to email them afterwards. Their contact information will be available. And also, those of you who need MCLE credit, please contact Heather Ward, whose contact information is in the link to the Zoom program, and she can send you the necessary certificate to claim credit. And without further ado then, let me introduce Damien Schiff.
Thank you, Dan, for the introduction. Thank you to Kronick for hosting today's MCLE on the Sackett case. And as noted, I'd like to start off just a little bit with the facts of the case, which I think are really important in assessing the scope of what the Supreme Court ultimately held, and then talk about the case, and then go on to give a few of my thoughts about where I think the next steps are with respect to the Clean Water Act and how it will be implemented, in particular the Sackett decision. So I'd like to start off with a slide that shows an aerial view of the Sackets property. This was part of the administrative record. And I think it'll give you a sense of literally the lay of the land. You'll see sort of in the center of the screen, there's the red rectangle. That represents the Sackets property. And you can see that it's within an existing residential subdivision. There's a row of houses that separates the Sackets lot from the Priest Lake. And then immediately north of the Sackets lot, there is a county road that's called Kalispell Bay Road, which is about 30 feet wide. And then north of that road, there is a ditch that drains a fen wetland of about 36 acres that is also north of the road. The Sackets bought this 2/3 of an acre residential lot in 2004 with the hope of building their family home on the property. And as you can see, when they purchased it, this area was taken in 2008. The subdivision in which they purchased it was already largely built out. And the lot that they purchased had a sewer hookup, it had a mailbox address, and it was otherwise fully zoned for single-family home construction by Bonner County, Idaho. So about 3 years after acquiring the lot, the Sacketts had then obtained their local county building permits necessary to begin construction of the home, which they started to do in the spring of 2007. Now, this is just taken last year, an aerial view. You can see that essentially the topography is the same, and then again highlighting the fact that there's about 300 feet or so that separates the Sacketts lot from Priest Lake itself. Okay, so this is the Sacketts property in early May, just after they had started laying gravel on the site to construct, for a building foundation to construct their home. And within about a day or so of that work having commenced, agents from the EPA and the Army Corps of Engineers came onto the property and essentially gave the Sacketts construction crew a verbal stop work order, saying that in their view, they thought that the site contained wetlands and that these wetlands were regulable under the Clean Water Act. And when that happened in the spring of 2007, this was truly a shot out of the dark to the Sacketts, who up to that point had never been informed by anybody, whether it was their seller or whether it was the county or whether it was their own research or anything in the chain of title or any of their new neighbors, that this site contained wetlands, much less wetlands that would require a federal permit in order to develop. So this is really quite a shock to them, especially since it represented an immediate obstacle to their plans to build their dream home. About 6 months, and before going to, I'll just finish the lay of the land. So this is, if you recall, I said immediately north of the county road that borders the Sacketts lot, there is a fen wetland. And this is what that wetland looks like, where the drainage ditch is in the springtime. And then there you see a better shot of this drainage ditch, which ultimately connects to Kalispell Creek, which then flows into Priest Lake. And as the water molecules travel, it's about a couple of miles for that to happen, in any event. So the EPA and the Corps said that the Sacketts were violating the Clean Water Act. Now, I'm sure most people in attendance today know exactly what that means, but in case anybody is unfamiliar with the Clean Water Act, the statute says that you can't discharge pollutants without a permit into waters of the United States. And the term waters of the United States has been a source of significant litigation over the last 50 years, since almost as long as the Clean Water Act itself has been on the books, since 1972. The dispute has been essentially how far beyond actual navigable, in fact, waters does the Clean Water Act reach? And over the course of the last 40 years, the Supreme Court, prior to the Sackett case, had tried to answer that in 3 different decisions. The first one coming in the mid-'80s, called Riverside Bayview, where the court was asked to decide, all right, well, we know that the EPA and the Corps can regulate navigable rivers, that goes without saying, but what about wetlands that are immediately adjacent to those rivers or other navigable bodies of water? And the Supreme Court unanimously held in Riverside Bayview that yes, EPA and the Corps can regulate wetlands that are immediately abutting otherwise navigable, in fact, waters. So that was, in a sense, a win for the agencies. Fast forward about 15 years, the Supreme Court in the Swank decision of 2001 looked at the other extreme, which is, all right, we're not talking about waters that are immediately abutting other wetlands. Now we're talking about, quote unquote, isolated waters. What about waters that have no direct physical hydrological connection to navigable waters, isolated ponds, for example, as they were in Swank? Can those be regulated under the Clean Water Act? And the Supreme Court said no. So then you had these bookends of the court saying immediately abutting wetlands can be regulated. Isolated waters cannot be regulated. What about the middle question? What about waters or wetlands or ponds that are not right next to a navigable water, but nevertheless are not totally isolated from navigable waters? What do you do there? Well, the Supreme Court in Rapanos in 2006 tried to answer that question. But as I'm sure many of you know, the Supreme Court was not able to produce a unanimous, or I should say a majority opinion saying what the rule should be for these sort of middle waters. And it was that issue ultimately that the Sacketts would address. So going back to the timeline, the EPA and the Corps came on to the Sacketts property in the spring of 2007 said, stop building the home. They followed up that verbal order about 6 months later with a written compliance order. And this compliance order essentially said that the Sackets had violated the Clean Water Act because they were trying to build in wetlands that were regulated without a permit, and therefore ordered the Sackets to restore the property to the way it was before they started working. And if they didn't immediately embark upon this restoration project, they would be liable for, at that point, tens of thousands of dollars per day in civil and administrative penalties. So a pretty significant order, and one that, as you can imagine, made the Sackets very much concerned about not only the future of their home building project, but their own personal financial futures. So it was at that point that the Sackets, through their existing local council, came to PLF and asked us to take their case to challenge EPA's assertion of authority over their home building project, and we certainly agreed to do that and filed our lawsuit in the spring of 2008. There was an obstacle, though, to getting to the merits. The lower courts held that we had sued too early because we were not allowed to challenge EPA's compliance order because it wasn't allegedly final agency action. The Supreme Court took up the Sackets case in 2012 and held unanimously that that was not correct, that in fact the Sackets could sue, the compliance order was final agency action. So the case was sent back down to the district court to now get to the merits, which again were, does EPA have authority over the Sackets property? Are there, quote unquote, waters in the United States on their residential lot? And in affirming EPA's authority, the district court and the Ninth Circuit Court of Appeals said, yes, EPA has authority because we believe that the wetlands that are alleged on the Sackets property have a significant nexus to Priest Lake itself. And even though the Sackets property is not itself navigable, nevertheless, because of this quote unquote significant nexus based upon certain physical and chemical and biological connections, we think that it essentially can be regulated along with things like Priest Lake. And in adopting that test, the Ninth Circuit was following what Justice Kennedy had argued in his concurrence in the Rapanos decision, which I mentioned back in 2006 was the first time the court tried to address this middle question about waters that weren't totally isolated, but at the same time were not directly abutting a traditional navigable water. And even though Justice Kennedy's opinion was just a single concurrence, nevertheless, it had significant influence in the lower courts, as demonstrated by the fact that it was used by the district court as well as the Ninth Circuit in the Sackets case to affirm EPA's authority over the Sackets home building project. Now, this slide is not meant to show off any sort of PowerPoint formatting skills that I have, but rather I just wanted to emphasize, because this is the official test, so to speak, the significant nexus test. I formatted this way just to emphasize how, in my view at least, this test is pretty complicated. It's got a lot of moving parts, and each part is, I think, fairly opaque. That not only do you look at whether your own property has a connection to navigable waters, you also look at whether other properties in the region that are similarly situated have a significant and less than insubstantial, more than insubstantial physical, chemical, biological impact. That was the test that not only the Ninth Circuit used to affirm EPA's authority over the Sackets property, but it's also the test that EPA itself very much relied upon to justify its authority more generally in terms of rulemaking and in terms of its defense of its authority in this Sackets case itself when it got to the Supreme Court. After the Sackets lost in the Ninth Circuit in the summer of 2021, they asked the Supreme Court to take up their case again and asked the court to decide this question of this: when do wetlands qualify as waters of the United States? Should we use the significant nexus test to answer that question, or should we use instead a different test? And the different test that the Sackets offered in their briefing in the Supreme Court was essentially a version of what Justice Scalia had argued for way back again in the Rapanos decision, which again was a split decision, no majority opinion. But Justice Scalia wrote a plurality opinion in which there were a total of 4 justices who were on board with what he wrote. And his view was that, well, for a wetland to be regulated as a water, you need 2 things. First, it has to be some feature that you would normally call a stream or creek or river, not something like an ephemeral wash or a drainage ditch or swale. And secondly, the wetland has to be so connected with this quote-unquote ordinary parlance water that you can't really tell the two apart. That the one blends into the other so much that it would really be arbitrary to sort of draw a boundary line between the two. If you've got that kind of a connection, then according to Justice Scalia, at least you've got a regulable water. And that's what the Sackets offered as sort of the main test to the Supreme Court. But they also went on to argue secondarily that, well, just because you've got a water, you can't necessarily say that you can regulate, because the statute says waters of the United States, not just waters. So what does of the United States do? How does that further narrow the set of regulable features? And to answer that question, the Sackett said, well, we look to sort of Congress's traditional authority over water, that the Constitution doesn't have a waters clause. So traditionally, it's been understood that if Congress is regulating for environmental matters, it's using its Commerce Clause authority. And the Commerce Clause is applied to waters generally pans out to mean channels of commerce. Navigable waters can serve as channels of interstate commerce, therefore Congress can regulate them. So our argument, the Sackets advanced, was of the United States means that this water is somehow usable as a vehicle, as a channel of commerce. And that's what Congress meant when it used that prepositional phrase in the statute. Okay, well, as Dan mentioned in the introduction, the case was decided May 25th of this year. It was argued the first day of the term last year. And in reaching the decision, I think it's important to, as we start talking about what the Supreme Court held, I think it's important to emphasize that it was unanimous in two important respects, that there were no dissents. There were some concurrences, and there was a majority opinion, but there were no dissents. So the two unanimous aspects of the decision are, one, that significant nexus test, which had its origin in Justice Kennedy's Rapanos concurrence, which EPA and the court very much relied upon, not just in the Sackets case below, but also in cases throughout the country, which they very much relied upon in their prior rulemakings, as well as the current rulemaking that's now being challenged that was issued earlier this year by the Biden administration. That significant nexus test is no good. No justice said that was the right way to interpret the statute. And as a corollary, the second unanimous point is they all agreed that the Sackets property should not be regulated under the Act, or properties that are sort of similarly situated, meaning that they are not physically, hydrologically connected to any other plausible, regulable water. So on that point, I think it was a pretty significant rebuke of at least the arguments that EPA and the Corps have been offering for some time as to how best to understand the statute. Now that, unfortunately, is where the unanimity ended, but there is not the same type of confusion in the Sackett decision as you had back in Rapanos, where there truly was no majority opinion. Here in Sackett, there is a clear 5-justice majority opinion written by Justice Alito, joined by the Chief Justice, Justice Thomas, Justice Gorsuch, and Justice Barrett. And this is essentially the opinion that I think one would look to decide what is the holding of Sackett, in addition to the two unanimous points that I mentioned on the prior side. So Justice Alito's opinion essentially, and to put it more bluntly, if I were asked at a cocktail party, give me in 5 seconds, what's the holding of Sackett? I would say the holding of Sackett is Justice Scalia's Rapanos plurality opinion. You can basically read that and you'll know exactly what Justice Alito is doing. Because essentially he adopts all of the reasoning that Justice Scalia gave for what do you understand what water means when it's used in the statute, and how do you determine that a wetland can be a water. The rationale is essentially indistinguishable. Justice Alito might add a few additional reasons for that conclusion, but I think the bottom line result is the same. So the first step that Justice Alito does, following Justice Scalia, is what's a water? And he uses your normal textual analyses, certain canons of construction, to say that a water is something that you would call in ordinary parlance, something like a stream, a creek, or a river. It's something that has water in it, if not continuously, it's certainly marked by the regular presence of water. That hydrogeographic standard is what the court, I think, adopted as what do you call as a water, as well as, at the very least, some sort of physical connection to a traditional navigable water. So that I think is more or less, as I say, an adoption of what Justice Scalia wrote 17 years ago in Rapanos. Secondly, when can you regulate a wetland? Well, if it has a continuous surface connection to the quote-unquote water, such that you can't tell the two apart. And that second part of the test, such that you'll see in the Alito majority opinion, the court uses different phrasing in different parts of the opinion, but I think essentially it's all getting to the same idea, which is that there has to be a line drawing problem. If you, as just an ordinary observer, can go to a site and say, oh, there's clearly the water, and here's the wetland, I think that it's under the Sackett standard that wetland can't be regulated. The rationale, again, that Justice Alito gave in the opinion is very much consistent with what Justice Scalia was arguing on the same point in Rapanos. But I mentioned that there were concurrences, and I think the most significant concurrence was that written by Justice Kavanaugh, which in some respects functions like a dissent, because Justice Kavanaugh, although he agrees with the outcome, that EPA's test is wrong and that the Sackett should win, he thought that the majority opinion would leave too many wetlands unregulated, at least with respect to the Clean Water Act. And he would have adopted a standard a little more generous to EPA, one that would regulate not just what he would consider adjoining or abutting wetlands, but also wetlands that have some degree of separation from a regulable water, but not a whole lot of separation. And admittedly, you can read his opinion for yourselves. I don't think he really explains the distinction between just a little bit of separation so that it's still regulable and a lot of separation that it's not regulable, except to the extent that he thought that the Sackets property should not be regulated. And the Sackets property is only separated by 30 feet from the roadside ditch, which EPA relied upon to then make the connection to Priest Lake and to sustain its jurisdiction.
Sure. On that road,
Yes,
and then the ditches to the north of it, I take it on the map.
correct, yes.
What's the flow? If there was no road there, no ditch, would it flow north, or would the terrain basically flow down toward the lake, such that the wetlands above it on the other side of the road would flow into the Sackett property?
I think the answer from the record is that there is, EPA would argue that there is a subsurface flow.
Okay.
But EPA itself would concede that there's no surface flow. Now, if you went back, say, 100 years before that road was built, I suspect that there would have been some sort of continuous wetland feature.
Okay.
But I doubt that even then it would have been a continuous surface connection. Because that photo that I showed earlier where it looked like the road was operating as functioning as something like a dam, you had a high water level, I think that's somewhat unnatural because that was snow melt and the road was sort of preventing kind of a natural absorption. I think if that road weren't there, you wouldn't see standing water like that. But as far as Justice Kavanaugh's standard, he thinks that the standard should just be whether the wetland is adjacent or not. And adjacent in his view is a matter of ordinary meaning, that you can say that something is adjacent to something else, even if it's not necessarily immediately touching. That you can say my house is adjacent to my neighbor's house, even though I don't share a wall with my neighbor's house. So in any event, his test, although broader, nevertheless, in his view, still would have accepted the Sackets property. There were two other concurrences, one written by Justice Thomas that was joined by Justice Gorsuch, and he essentially goes one step further than the majority opinion. If you recall, the Sackets were arguing not just what should be a water, but also when is a water of the United States. The majority opinion by Justice Alito doesn't address that second part. He leaves, just like Justice Scalia would have done back in Rapanos, leaves that for another day and says, we're just trying to figure out what is a water and when is a water a wetland. We're not going to determine, in this case, when is a wetland or water of the United States. But Justice Thomas says, well, I would. And he more or less, I think, adopts what the Sackets were arguing, which is, water of the United States is a physical body of water that could function as a channel of interstate commerce, which naturally the Sackets property couldn't do that, but for that matter, certainly not the roadside ditch or even the creek that leads into Priest Lake. Justice Kagan, although she also joined Justice Kavanaugh's concurrence along with Justices Sotomayor and Jackson, she wrote her own concurrence, which is somewhat of a pointed criticism at the majority. Her focus is not so much on the standard as opposed to what she thinks was the majority's improper statutory interpretation, that she thought that the majority was not being faithful to Congress's intent behind the Clean Water Act, that Congress specifically wanted to limit private activity on private property because that could lead to pollution. And yet the majority opinion, in her view, was sort of reversing that, saying that we should protect private property regardless of the water quality impacts that activity could have on private property. So as I say, it's more of a kind of a methodological or policy-based criticism. She would have agreed with Justice Kavanaugh on the question of adjacent wetlands. Okay, who has the better argument? Well, I think for anyone who's interested in jurisprudence generally, I think the Sackett decision is a great case in point, because here you have a battle of textualism. We hear so much nowadays about textualism as being the reigning theory of statutory interpretation. You really see it on display in the Sackett decision because everybody is saying, I'm a textualist. It's not as if one opinion is saying, well, you should rely upon legislative history more, or the purpose of the statute. Everybody is saying, I've got the best interpretation of the text, but they don't agree on what that best interpretation is. Justice Kavanaugh says, I look at the text and I see here in section 404 of the statute, which authorizes, among other things, EPA to transfer certain types of Army Corps permitting authority to the states. I see here in this section of this permitting authority transfer provision, 404G, there's a reference to adjacent wetlands. It says here that EPA can transfer permitting authority except for discharges into certain types of traditional navigable waters and quote unquote wetlands adjacent thereto. So it seems here by implication that Congress clearly thought that certain types of wetlands could be regulated, and the ones that it thought that could be regulated are adjacent wetlands. So for him, the text in section 404 of the Act is determinative. Contrast with Justice Alito, he says, yes, we're textualists too, but we will not take seriously textualism that ignores the quote-unquote operative text. And his opinion is all about the operative text, that is the provision of the statute that defines all of the terms. Section 502, which among other things defines regular waters as the waters of the United States. Doesn't mention wetlands in that definitional section. So Justice Alito says, we look at the operative provision first, and we're going to privilege that over any other reference in the statute to wetlands. Because we think if Congress had really wanted to regulate wetlands that way, it would have just amended the definitional section itself. It wouldn't have just simply added a passing reference to wetlands in some other permitting provision. The fact that it didn't do that tells us that our standard, which is a little more demanding, is the appropriate one. So I think in that respect, Sackett is really sort of emblematic of a general shift in the court's approach. I mean, you could read, say, the Riverside Bayview decision, the first Clean Water Act case talking about waters in the United States from the mid-'80s, and you look at that and compare it to the opinions in Sackett, and it's a total change. I mean, most of the Riverside Bayview opinion talks about legislative history, talks about the importance of wetlands for water quality, talks about deferring to the Army Corps' expert judgment in terms of what it needs to regulate in order to vindicate Congress's purpose. Fast forward, 40 years, there's almost none of that present in any of the Sackett opinions. So it really is an interesting kind of microcosm for what's been going on more generally. And there are a few other things there that I note on the slide where I think you can talk about who has the better argument. One thing I do want to focus on, since I'm running a little late over on my time, is this question of canons of construction, which plays a big role in this dispute in the different opinions. That one of the main sets of reasons that Justice Alito gives for rejecting EPA's significant nexus test is that it would violate two canons of construction in particular. One, the idea that Congress respects the traditional federal-state balance of power, and that traditionally states have primary authority over land and water resources, and yet the significant nexus test would invert that, would make EPA and the Corps the primary regulator, and that seems inconsistent with what Congress traditionally does. And the second canon being that, kind of like with vagueness and due process and the desire not to interpret a statute in a way that might raise a constitutional question, the court says, well, look here, the Clean Water Act is a very penal statute. I mean, you can even just violate it innocently and still be liable for tens of thousands of dollars per day in fines. A mere negligent violation could put you in jail as a federal felon. Given those significant penalties, don't we normally expect Congress to be very clear as to what's regulated and what's not? And yet the significant nexus test doesn't seem to be clear at all. That's another reason why we, Justice Alito would say, reject that interpretation. Now, the use of those canons gets a lot of criticism from Justice Kagan in particular. I go into this a little bit more in the written materials that I think were distributed as part of the CLE, and I'll defer to that if you were interested more in learning about that. But I think you'll see how these canons of construction will continue to play a big role, particularly in environmental law. West Virginia v. EPA, the Major Clean Air Act case from last year, is another example of canons playing a big role. And of course, in this past term, in cases like the student loan cases, non-environmental cases, nevertheless, these canons play a big role. And Sackett is no exception. All right, well, what's next? As I mentioned, EPA had been using the significant nexus test in a lot of its rulemaking over the last decade, most prominently in its latest rulemaking concerning waters in the United States that was issued in January of this year. It's already been challenged in a number of cases, and it has been preliminary enjoined in a number of jurisdictions. Nevertheless, the administration is still defending it. I think it's hard to defend as currently written because it's based primarily on a test that the Supreme Court has now abrogated. So that's hard to defend a rule that's been constructed that way. And perhaps not surprisingly, the administration has said, well, we're going to do an amended rule that we intend to promulgate on September 1st without notice and comment, which I think for anybody who's familiar with administrative law might say, well, that seems a little out of the ordinary, at least especially with respect to such a significant issue as waters in the United States. So I wouldn't be surprised if that is also challenged. And then finally, what will EPA and the Corps, or those who want a broader Clean Water Act, what will they do? Well, I think one thing that will certainly happen is you'll see an increased reliance on sort of alternative theories of liability, the idea of an indirect discharge, which the Supreme Court essentially blessed in the County of Maui decision from 3 years ago, where you can be liable under the Clean Water Act if, in some circumstances, if your discharge pollutants ultimately end up in a regulated water, even if you didn't immediately put them into a regulated water. So, for example, if the Sackets had dumped pollutants into the roadside ditch, that roadside ditch might not be regulated, but if ultimately those pollutants were to wash downstream into Priest Lake under County of Maui, there might very well be liability. So I think you'll see reliance upon that theory much more than you have been, although it may not be quite an end run for 404 litigation, which typically involves pollutants that are designed not to move around. So it may not be as helpful there, but in the 402 context, it may very well be more prominent. Well, that is my presentation in chief. I appreciate your attention, and now I'm going to segue over and we can move into our Q&A.
Great. Well, thank you so much, Damien, for that overview. That was really helpful. And I think the first question I have for you, so just so everyone knows how we're going to do this, Brenda and I are just going to ask questions. It's going to be a little bit more conversational. And yeah, we'll go from there. So the first question I have for you is that now that Sackett is decided, do you foresee litigation related to similar topics? And I guess, and overall, the question being, do you think this decision minimizes or settles down litigation, or does it actually give rise to other potential litigation that's going to speed up now that this is decided?
You know, I think any Supreme Court decision that announces a new test is always going to engender some degree of litigation because it's a new test and we need to figure out, well, how does it play out in different facts? I certainly hope that we'll see less confusion and less litigation using the Sackett standard than we have seen over the last decade and a half with the significant nexus test. I do think there are, despite the fact that the decision articulates a rule that I think is much better than what we had before, I think it does still have some ambiguities, which even Justice Alito noted, that will require litigation and maybe rulemaking to tease out. And maybe these are things that EPA and the Corps will address in September. One example is, what do you do when the continuous surface connection that you need for wetlands jurisdiction goes away because of peculiar climatological events? The court even has a footnote where it says, we don't express any opinion about whether in, say, if there's a big drought and where there normally would be a continuous surface connection, that's not there temporarily. We're not going to say whether, well, maybe that might be an exception to our test. Another area where I think there may be some confusion is, what does it mean to be a relatively permanent water? Do you need to have water continuously present, which is the only description that Justice Alito uses. He just says the continuous presence of water. Does he really mean that, strictly speaking, that even a seasonal water, much less, an intermittent water, can't be regulated? Or would he allow for, say, a water that, always has flow in it from winter to spring, but then in the summertime dries up? Would that be regulable? I think there's some ambiguity there, and it will probably take litigation or rulemaking to resolve it.
So on that note, so it seems like there's still a lot to come as to figuring out how Sackett will help determine whether other types of waters, like ephemeral streams and intermittent streams, seasonal, as you mentioned,
Right.
are jurisdictional. So is there anything else you see that might still need to be delineated from Sackett in addition to wetlands, as we're sort of dealing with this new test?
I certainly think so. I mean, in some parts of the country, I think actually this relatively permanent water issue will be even more important than the question of wetlands jurisdiction as such. I think of a place like Arizona, for example, where almost all of the Clean Water Act permitting litigation focuses on quote unquote ephemeral features or dry arroyos or washes or swales or all of these things that have been plausibly regulable under the significant nexus test, which I think now are going to be very hard to justify under the new Sackett test. And even though Sackett, I think, is primarily a case for wetlands jurisdiction, I think in this respect, it will have a big impact outside of strictly speaking wetlands.
So some critics, of course, have described this decision as one that significantly rolls back water quality protections. And how would you respond to that critique?
Well, first of all, you have to ask what the baseline is. I mean, I believe that what the Justice Alito majority opinion does is simply align the case law with what Congress wanted to do in the statute itself. So if there's a rollback, it would be a rollback from what EPA and the Corps have been interpreting the statute to do, which I think, and the majority opinion is Sackett, and even the concurrence is thought was too far. So to be fair, I think on the ground, certainly Sackett's going to result in a reduction of EPA and the Corps' authority. But I don't think it's fair to say that necessarily that means that there are going to be worse water quality outcomes. For one important reason, in that the Clean Water Act is not field preemptive. It allows the states to regulate more strictly than any federal standard. And I think here in California is a great example of how the water boards and the legislature not only have done that, but I'm sure will continue to do that. And so in that respect, I think the concern about water quality harms is overstated. And even in those jurisdictions that choose not to regulate as California does, to not keep on regulating as EPA and the Corps used to, who are fine with less 404 type dredge and fill regulation, that ultimately is a policy judgment. It's no different from any other policy judgment that you have one state legislature going one way, another state legislature going another way, balancing certain water quality concerns with, for example, housing production. And who's to say, what's more important? I mean, that's a normal political question And the mere fact that one jurisdiction might come out a little differently from another, I don't think means necessarily that the decision that enabled that multiplicity of approaches is wrong-headed.
So what do you think is next for wetlands and WOTUS, or Waters of the United States delineation? Do you think this will spur Congress to act, or is this going to remain in the purview of US EPA to handle through rulemaking?
Well, it's interesting, what does Congress think about this? The Sackett case garnered a lot of amicus attention. And among the amicus briefs, there was sort of a competing congressional amicus briefs. There was one amicus brief submitted on behalf of certain members of Congress, senators supporting the Sacketts, and another one submitted on behalf of other members of Congress, other senators, on behalf of EPA. And there were a lot more in favor of the Sacketts, even taking into account partisan differences. So I think actually Congress is probably okay with what the Supreme Court has done. Another good example of a piece of evidence for that is there was a Congressional Review Act resolution that was passed by both houses of Congress while the case was pending earlier this year. Both the Senate and the House approved a resolution that disavowed the current administration's WOTUS rule, saying that it went too far. Now, of course, President Biden vetoed it, but the fact that even in this Congress that could get through, I think demonstrates that that I don't think the Congress wants to expand the scope of the statute. I think they recognize that the more narrowed version that the Supreme Court has articulated is appropriate.
So I've got a question about the type of pushback you may have received on the Sackett case for the years leading up to it and while you were preparing the case, especially at the lower court levels. Did you get pushback from the development community? Because especially in states like California, where we rely on Section 404 permits to get our Section 7 incidental take under the federal ESA, Endangered Species Act. And if 404 is more restricted and there's just not so many 404 permits going around, then maybe California is not a good example, but did you get pushback from them because now more projects might have to go get incidental take under the Section 10 of the Endangered Species Act?
Well, I can say certainly in the first part of the case, which I just mentioned briefly, dealing with just judicial review and whether you can even bring a lawsuit against EPA based upon a compliance order having been issued, that I think that there was essentially unanimous support for what the Sacketts were doing. And on the second part of the case, certainly at the national level, I would say there was also consistent support in terms of the amicus briefs that I mentioned, home builders and other sectors of industry that are highly regulated under the Clean Water Act. They were all supporting the Sackett's position. But you raised a very good point about how in places like California, the impact of the Sackett decision might not be entirely positive from a development perspective, precisely because I think oftentimes there was the thinking that by relying upon a connection to the Clean Water Act and 404 permitting, you could effectively streamline your state approvals because California would require otherwise pretty significant mitigation or other permitting requirements that might not be as demanding if there were a federal connection. So in a state like California, I think there could be instances like that, but I think at a national level, those who are interested in the productive use of private property, who are interested in home building and such, agriculture, have been very supportive of what the Sacketts have done.
And speaking of California, how does this case apply to California? Does it impact anything here?
Well, yeah, I mean, again, as I mentioned earlier, since the Clean Water Act is not field preemptive, is essentially agnostic about whether the states want to regulate more strictly than federal standards. And so the legislature and the water boards and other state agencies, I think, had already made clear, even after the Supreme Court's decision in Swank and Rapanos, going back now, 20 plus years, that they were intent upon regulating the quote-unquote gap. That is, that segment that at some earlier point might have been federally regulated, but now is not because of changes in the case law. And I think that, I suspect that they would continue in that policy.
Are you anticipating differences in how different states will respond to the decision? Are we anticipating increased legislative and regulatory action kind of across the board, or
Yes.
is it going to be a patchwork?
Oh, I think more of the latter, but I think whether you call a state, red, blue, or purple, I mean, I think there's definitely going to be a legislative response, in part because a lot of, quote unquote, red states during the last decade or so had amended their water quality laws to be tied into what the feds were doing. And I think part of the idea was that, well, since the feds are already regulating so broadly, it'd be foolish for us to regulate even more broadly. So we're going to just simply make sure that if you satisfy the federal standards, you've satisfied anything that we, the states, might require. Now, of course, you have the question, okay, well, since the feds are regulating a lot less because of the Sackett decision, should state law still maintain that same parallel approach? Or would it be appropriate for the state to regulate a little bit more? I think a state like Arizona would be a great example of where this debate's going to be happening, because I believe Arizona does have a statute whereby they were not going to regulate further than the feds. But now that so much of what the feds have been regulating probably won't be regulable. What should be done? And I think another example is New Mexico. Already New Mexico has been thinking about enacting a new permitting since they don't have delegated 402 authority, a new 402 program, like 402 program at the state level in response to Sackett. But then there'll be states, Idaho, Wyoming, Montana, what have you, that will I'm sure be fine with the status quo of what they've been doing.
So turning more to your experience arguing at the Supreme Court and the path to getting there, what did your team look like for this case? Like, how much support did you have from maybe more junior attorneys? And then also, did you hire like special counsel or other advisors especially when you were at the U.S. Supreme Court level?
Well, we were and are leanly staffed, and not a whole lot of additional help. When the case started, I was the junior attorney on, and I had one attorney, senior attorney, very prominent environmental law practitioner, Reed Hopper, who was our supervisor attorney, and it was just the two of us for a good amount of time. And then when we went back up the second time, we had 3 or 4 people who were on the case directly, but it was always very leanly staffed. Now, part of that is that because this case was brought under the Administrative Procedure Act, there was just an administrative record. There was no discovery. There were no evidentiary hearings. And in fact, it's remarkable too when you think about how big administrative records can be, hundreds of thousands of pages. I think the administrative record in our case was about 200 pages. I mean, it really, and the reason why, of course, is because the administrative record was compiled at a time when EPA was not expecting that it could be sued. At that time, compliance orders were not judicially reviewable, so they didn't really feel like they needed to put a lot in the record because they weren't expecting they would ever have to turn it over. And so that is a little unusual that the record would be so small in a case like this. But in any event, that certainly was a big part of it. Had it been a case where with an open record or discovery, certainly would have required a lot more people power.
What was one of the most difficult questions that a justice asked you during the argument on this case?
Yeah, I would say the toughest one, one of the toughest ones came from the Chief Justice, and it was in part tough because kind of going into it, I thought, who's sort of on the fence, who's probably against us, and who's probably for us. And I put him in the probably for us camp in part because he signed on to Justice Scalia's Rapanos plurality opinion back in 2006. So he sort of already made public his view. And I thought, all right, well, we're basically arguing the same thing. He should like that. But he asked a question about what do you do with wetlands that have a seasonal connection to, a seasonal continuous surface connection to regulable waters. You know, kind of like the Nile Delta, that every year you know you're going to have this line drying problem for a few months of the year, but then it's going to dry up. What do you do? And that was a hard question to answer because I don't think there is a good answer, at least not in terms of just, well, what does the statute compel? Or what did Justice Scalia say about it in Rapanos? I don't think there was a good answer. So my answer was basically, well, that's an example of where rulemaking could be helpful, you know? to clarify. And he had a very sort of, he wasn't angry or anything like that, but he I don't think he was totally satisfied by that. But the majority opinion doesn't address that issue either. So I don't think anybody on the bench had the right answer.
So how did you prepare for what they might ask you? You sort of said that you had kind of classified the justices into different kind of camps almost. So did you have like a strategy for each camp or like, tell us how you kind of prepared in that way? Well,
you know, one thing that was very important in prepping for the briefing and the argument was something that I think I failed to mention in my PowerPoint presentation, which is the court in granting cert rewrote the question presented. We had asked, basically our question presented, okay, court, do we take Scalia or do we take Kennedy? Which of these competing Rapanos opinions is the right one? Because that's essentially how we had argued the case below. And in granting cert, the Supreme Court said, what is the correct test? Without any reference to Rapanos or anything else, except that they cited the statutory definition of waters in the United States. But what is the correct test for wetlands jurisdiction? So that was a signal like, oh boy, well, that means that we should be maybe a little more ambitious and not feel so constrained to the precise case law up to that point. So that's one reason why in our briefing, we added this bit about what does of the United States mean and all that. But also that was a cue to us that there were people on the court, justices on the court who didn't like the status quo, but might not be satisfied with what was in Rapanos. They were looking for some third way. And now we know that, yeah, there were at least 4 of them who were looking for a third way, who were not totally happy with what was in the Rapanos plurality. So that was a big part of the strategy. And then just in terms of the nuts and bolts, as one would do with any oral argument, whether it's a district court or a court of appeals, that you have moot courts. And especially I found helpful was the outside moot courts, where we had people who were well-versed in the law and in appellate advocacy and in environmental law, but who were not connected to the case. So they were looking at it with fresh eyes, and they could pop questions that I might not have thought about otherwise, and that really helped in terms of preparation.
When the decision came out, were you at all surprised by the reasoning and conclusions, or did everything just kind of make sense? It was what you expected based on the arguments and briefing?
Well, you know, certainly another part of the oral argument that was a little challenging for me at least was that there were a lot of questions from the bench about this section 404G of the Act, which Congress added in '77, which does contain this parenthetical reference to adjacent wetlands. And not only Justice Kavanaugh, but Justice Kagan, but also even Justice Barrett, and I think even Justice Thomas asked questions about that. And it was caught me a little flat-footed just because not only was that issue not of significance in any of the moot courts, but also it received almost no attention even in EPA's briefing. I mean, it was kind of an additional point that they relied upon that, oh, hey, look, you know, there's a section of the statute that talks about wetlands, so that supports our view, but it wasn't the fulcrum of their case. And so that was certainly a bit of a challenge.
Mm-hmm. How far in advance did you and PLF feel pretty sure that this was going to the Supreme Court?
Well, you know, it was after the first Supreme Court win and we went back to the district court, it took us a long time to get to the merits, in part because of some record squabbles, but also just, I think, because of docket congestion. It took the district court a long time to adjudicate the case. We were in the district court for 7 years on remand. And during that time, it wasn't clear what was going to happen because there was the 2016 election, and one of the main things that the Trump administration wanted to do in environmental law was adopt a durable definition of water in the United States that would have been a lot narrower and would have given the Sackets relief. So for a long time on remand, we were thinking, well, maybe the regulatory history will catch up with us and will essentially decide the dispute. But precisely because the remand took so long, it took us through the Trump administration to the Biden administration, which then did a complete about-face and said, no, we're not going to regulatorily reduce the scope of the act. We're going to return it to what we think it should be, and that means the Sackets property and a lot of other property is still regulated. If the remand had not gone on as long as it did, it might have been a different outcome.
Did your strategy change as the members of the court changed? Obviously, we're looking at a very long time horizon, so there
Yes.
was quite a bit of change on the
Yes.
court.
Well, I think that's another instance of where the long remand actually helped. Because I don't think the court was prepared to take up this WOTUS issue with Justice Kennedy still on the court. Because he wrote the significant nexus test, and towards the end, one of the very last cases he had was a 2016 case called Hawks, dealing with judicial review of Army Corps jurisdictional determinations. And in that case, he had a concurrence saying, yeah, I think there are problems here. So towards the end of his tenure, even he recognized that the significant nexus test was not the bee's knees. But I think the court was not prepared to address the issue again until he had left the bench. And so that, I would say, in terms of court personnel, I think that was the most significant change.
What about, you had mentioned amicus parties earlier, and when you're considering who to, either invite or ask to, write an amicus, what do you consider when you're brainstorming for that? And do they come to you? Do you ask them? Is there a little mix of both?
Before answering that amicus thing, one other thing I wanted to mention about Justice Kennedy was that he was at the oral argument in October, which I think he was there because it was Justice Jackson's first oral argument, so I was sort of like professional courtesy for him to attend. But I didn't know that he was there in the VIP gallery until afterwards. But the press report said that he was just essentially, poker face. He didn't have any expression, but I thought that was interesting that he would be there. Anyway, on the question of amicus participation, in terms, if you have clients who are who have a case that is Supreme Court worthy, I think amicus participation is critical at the cert stage. That there's plenty of empirical analysis that shows that even one amicus brief on supporting your cert petition dramatically increases the chances that the cert petition will be granted. And I think there's a diminishing margin of return after like 2 or 3. But I mean, definitely, and it doesn't even matter who's doing the cert petition. It could be a very well-known organization. It could just be somebody who's just interested in the issue. But that is where amicus participation is so critical. And oftentimes it requires that the attorney go out and contact organizations and say, here's an important case. I think that your clients or those you typically represent would be interested in it. We'd welcome your support. When it comes to the merits, if the case has been granted and now you're talking about merits amicus briefs, there it kind of shifts. It's that you then curate the people who want to file in your case. You very rarely do you need to go out and find people, because the fact that it's already been granted means that people know that it's important. So there it's more a question of gatekeeping, just making sure that, especially for those who otherwise would want to support your client's position, that they don't end up indirectly hurting your position by articulating a view in an amicus brief that they think is great, but that might somehow hurt your efforts. So, but in either instance, amicus briefs are important. And I think you'll see, like in the Sackett opinions themselves, there are a number of citations to amicus briefs that have been filed by water districts and by the states and environmental organizations. So it's definitely worthwhile at that level.
Thank you, and I know that we have hit the hour, so we'll stop our questioning here, but I want to say thank you so much, Damien, for joining us, and thank you, Brenda, for helping with the questions. Thanks to the audience. And thank you all for joining us today, and thanks to everyone on Zoom also.
Thank you.
Mr. Schiff,